Now, another week, another class action lawsuit filed against a major crypto project. Just last week, we spoke about a New York-based legal firm bringing a swath of class action lawsuits against major projects, major players like EOS, Block One, and exchanges like Binance and BitMEX, for example. Well, this week, in a California district courtroom, a new class action lawsuit was filed, and this time it's against the giant of decentralized finance, the Maker Foundation. The lawsuit claims that the company behind the MakerDAO ecosystem misrepresented the risks of utilizing their platform to investors, which led to extraordinary losses on March 12th amidst the market meltdown that we had. Now, we've got the link to the article here. Filed in a Northern District Court of California earlier today, Tuesday, April 14th, the lawsuit names 3 entities affiliated with the Maker organization, the Maker Ecosystem Growth Holdings Incorporated, the Maker Ecosystem Growth Foundation, and the DAI Foundation, alleging that they are responsible for negligence and intentional misrepresentation to the investors, or as the suit describes the plaintiffs, collateralized debt position holders. Where have we heard that term before? Contained in the complaint is a description of the losses sustained by these so-called collateralized debt position holders, putting the sum of their losses at about $8.3 million in Ethereum collateral held on the Maker platform, as collateral was liquidated when the cryptocurrency markets melted down in mid-March, Black Thursday, as many have called it. The lawsuit claims that the risk of such a scenario playing out was never made clear to these investors, describing the people behind the Maker organization as misrepresenting the dangers investors could be faced when using their platform. It also argues, the complaint goes on to allege, that the Maker Foundation neglected its fiduciary duty to investors by fostering a platform and conditions on that platform that directly precipitated the Black Thursday disaster. It also alleges that the Maker Foundation was wrong to actively solicit millions of dollars to be tied up in their, as yet, still experimental system. This formal complaint on behalf of the investors is asking for a minimum of $8.3 million in compensation, and it is a punitive lawsuit, meaning that they are asking for punitive damages. So it's $20 million in punitive damages that they're offering. So for those of you who are unfamiliar with the legalese of the court system or how the legal system works, punitive damages, they are awarded and they are asked for when there has been essentially horrendous wrongdoing. And they're not to really compensate the victim for anything that they actually lost. They are to punish, that's why they are punitive, they are to punish the defendant, whoever, if the defendant is found guilty. Now, it's generally pretty rare that punitive damages are offered. There's thousands upon millions, probably millions of frivolous lawsuits that are filed in the United States every single year. And many of them are going to be asking for punitive damages. It's become kind of common to ask for punitive damages, but it's one of those things that almost never gets awarded. So punitive damages are generally awarded when there is a significant amount of evidence that the defendants, or whoever is, the defendants who are accused of the crime or the civil breach of contract, really deserve to be punished for their actions. They can't really be held criminally, liable, potentially. Every situation is different. Some, obviously, the difference between this is in civil court, not criminal court. So they're not guilty of any criminal crime. But the idea of punitive damage is to punish an individual or punish an organization when their conduct has been pretty overwhelmingly destructive or negligent, right? Generally in the terms of fiduciary duty, which is what the allegation here is in this case. Now, the lead attorney pursuing this class action complaint, his name is Adam Hayter of the Harris Byrne Christensen law firm. And in an interview, he denied, obviously we covered last week, all this swath of lawsuits being filed against exchanges and big players in the crypto space. He denied in an interview that his firm had any relationship to the firm in New York, which just filed the spate of lawsuits that we discussed last week. You guys can check the Breaking Bitcoin Bits episode of that in our Breaking Bits playlist here on YouTube. Now, he was asked what he thinks will be Maker's fate if the judge happens to side with the plaintiffs in the matter, but he did decline to comment on the matter. Now, for me, now I can't let this go without, obviously, listen, in my opinion, we'll get to this in a second, I think the lawsuit is frivolous. Now, for me, this does highlight, not frivolous, but I don't think that it's justified. Now, for me, this does highlight an issue in cryptocurrency, right? And that is that trusted third parties are liability and lawsuit magnets. Obviously, the lawsuit filed against the exchanges and general are increasing in size. And these are the pinch point exchanges, are the pinch point of the fiat to crypto on-ramp. For many speculators, what drives the value of cryptocurrency is not its ability to facilitate payments or enhance freedom in the case of Bitcoin, but its ability to be converted readily into fiat currency, right? If that on-ramp wasn't so tangible or so critical to the purposes of many participants in the market nowadays, the value of cryptocurrency to hackers, lawyers, and governments would be significantly reduced. And this is yet another example of why it's very, very important for us to proceed with establishing these third parties with a lot of foresight, because situations like this can and have occurred and will continue to occur. They will continue to occur as long as these third parties remain the weak point for the crypto ecosystem. The other thing that is unfortunate about this is that meltdowns like what happened with the Ethereum position, right, is very similar. It's almost no different from the situation that happened with the massive law of liquidations on BitMEX. But in that situation, the BitMEX liquidation engine failed to work properly, and the exchange failed to work properly. Whereas with the MakerDAO system, nothing really failed to work properly. There just wasn't any competition as far as picking up. So, one of the big things that these individuals that the plaintiffs are upset about is that a lot of their Ethereum, their collateral was purchased for zero DAI because there was no competition amongst that market. Now, so what do you guys think? Does this lawsuit have any traction over a decentralized protocol like the MakerDAO system? A complaint by one of the plaintiffs, Peter Johnson, as I said, is that this exceeds the 13% max penalty that the Maker protocol promises. On the other hand, the auction system for liquidated collateral is written into the protocol just as well. And I can't help but mention that this does feel a lot like the DAO hack. Of course, it's not a hack, and these are different situations, but the argument over what to do with lost funds is exactly what split Ethereum into Ethereum and Ethereum Classic in the first place. And now we're back in the same situation. Overall, my opinion is that these are experimental protocols, and why I commend and admire individuals who not only develop but support the growth and development of these platforms, because I am all for these concepts, all for them. Investing at this stage lots and lots of money into unproven smart contracts and experimental protocols is very dangerous. You can support and develop and invest in a system without incurring a massive loss should you be completely wrong, especially with the volatility of cryptocurrency. The other thing that is unfortunate here is that as a strong Bitcoin advocate, situations like these give Bitcoin a bad name, which is wrong, because Bitcoin's been trudging along for 10 years now, doing the same thing without any of these problems. And I commend and respect Ethereum for doing what they're trying to do. I am totally for the idea of decentralized finance, but it's really hard for me to feel sorry for people who lose a lot of money on something that they knew up front was experimental, right? Now, there is a positive thing here, though, and that is that if anything ever were to happen with Ethereum or Link or EOS or Tron or USDT, expect an exodus into Bitcoin. Where are they going to go? They're going to go to Bitcoin, right? Same with USDT, where they're going to go into Bitcoin, right? So you're setting up, there is always this is what's kind of interesting about, and again, I guess a danger in the same way to those who short sell Bitcoin. There is always a danger of exponential movements to the upside coming in out of nowhere on Bitcoin, right? Of course, the exponential movement to the downside is always there. Appreciable assets can fall very quickly. Something to consider if you ever, when there is uncertainty in the market, you will often see Bitcoin perform and hold its value better than altcoins. This is how it's always been, right? Altcoins pump up faster and drop faster than Bitcoin. There's always this kind of potential Bitcoin pump situation always underneath the surface, right? But as far as this situation, I'm really interested to know what you guys think. Is it a matter of buyer beware, and investors should have been aware that in some extreme market conditions, their collateral tied up with Maker was at risk? I certainly think so. Please let me know your thoughts in the comment section down below here on YouTube. Let me know what you guys think. Please sound off.